The world is still watching you, Frances.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Good morning, everyone. My name is Michelle. I hope you're doing well. Welcome to another video. It is Tuesday morning, the 28th of November, and the day after the deadline for Judge Frances C Gull to submit her response to the second writ of mandamus and prohibition. Of course, this morning we're talking about the Delphi case again. Groundhog Day. I sit here day after day going over the same things because they keep coming up again and again and again. Anyway, yesterday we had two big court filings. I did a live stream fairly late last night, my time, with my first impressions of them. Hadn't read either of them in any detail. In fact, Gull's I hadn't read past the first page and a half. I have now read them in detail, and I want to start breaking them down. I haven't seen what anyone else has said about them as of yet. I've got a bunch of live streams from other creators that I follow to catch up on, but I want to start breaking these things down. So let's do a comparison between what the Attorney General Theodore Rakita and Judge Frances Gull said about the reasons why Baldwin and Rosie, Richard Allen's rightful attorneys, were disqualified. We've gone through these before. We're going to break it down and go through them again. There's a bunch of other stuff I want to talk about in these court filings as well, but I'll split them up into different videos because it'll end up being mega long. And I want to make these accessible, easy to follow. We're going to get on screen the filing of Theodore and the filing of Frances and do a spot the difference. And we're going to bring forward some evidence to refute their claims. Alright, so on the left-hand side of your screen is Theodore's, and on the right-hand side of your screen is Frances's. Now, Theodore Rakita, who is he? Just to remind you, he's the Attorney General for Indiana. He's the one who refused to represent Frances Gull when all of this writ stuff kicked off. It was one of the reasons why she asked for an extension for both writs, because she needed to get her own private attorney. Yet Theodore has come out in support of her, so just, I don't know, not responding as a lawyer, but as a colleague, trusted friend, someone who's got interest in this case. I think it was more of a political or strategic move for him not to represent her so that he could give his opinion as a person rather than working on behalf of her. That's what I think has gone down here. Of course, Theodore wasn't at the in-chambers meeting on the 19th of October, was he? No. He's only taking what is in the transcript and what Frances has said. As he says in this document, this is classic. He says that the record isn't complete. There isn't a proper record to say what went down. That's the heart of the matter, isn't it? All right, so this is what Theodore said. At an in-chambers meeting before the hearing. So the in-chambers meeting before the hearing. The hearing, remember, where Nicholas McClelland was all prepared with his witnesses and their exhibits, even though Rosie and Baldwin didn't know what the hearing was about, allegedly, because Rosie asked what the hearing was about, and she just told him to turn up at Chambers for a pre-hearing conflab. They thought they were going to discuss some points, not to be told that they were being disqualified. So no, they didn't have any witnesses or exhibits because they didn't know they needed them, because they didn't know that this was a disqualification hearing. There has to be a motion to disqualify, then the hearing, where each side can bring whatever witnesses and exhibits and stuff that they want. Judge Gull informed Baldwin and Rosie of her concerns regarding the defence team and the totality of the circumstances surrounding their representation. These were her concerns. In proper comments to the public, so this was about the press statement that they gave on the 1st of December, after stating that they would not talk about the case, but there was no gag order in effect, so therefore they could if they wanted. Conflict of interest, so we slipped that one in. Rosie filed a tort claim on Alan's behalf against Westville Department of Corrections. That was just a notice, not an actual case. It was a notice that they would bring a case in the future. So no conflict of interest. Not two cases going on at the same time. No. Okay, protective order violation. Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. No, he didn't release discovery to Brandon Woodhouse. This is just one screenshot I took of what was actually inadvertently in error. All right, this is the worst thing that Baldwin did. In error, right? He should check who his email and address thing is auto correcting him too. Filing motions with inaccuracies and falsehoods. The pleadings regarding the safekeeping order. So this is from the June hearing, where Baldwin and Rosie claimed that Richard Allen needed to be moved from Westville because there was horrible things going on. But based on what the warden and the guards said, she took their side. So whatever Baldwin and Rosie witnessed wasn't accurate. What they witnessed with their own eyes wasn't accurate. Baldwin and Rosie wanted to actually go and measure his cell, and that was denied. So they weren't able to provide any objective proof because that investigation was denied. Protective order violation, source of more leaks of discovery, which spawned a criminal investigation and may have resulted in a suicide. All right, so that's Theodore, but he wasn't there. But we'll keep that there. All right, let's read what Gull said. So she acted well within her discretion to remove Baldwin and Rosie, above and beyond Richard Allen's objections. The record supports that the trial court could reasonably conclude Baldwin and Rosie committed multiple violations of the rules of professional conduct, compromised Richard Allen's defence, and that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defence team. And there's a footnote here saying that she filed the transcript of the October 19th in-camera meeting with counsel as a supplemental record in response to their motion for transcript. Yes, and doesn't that tell a much different picture than what they're trying to claim here? So we've got the Mitch Westerman situation. Let me just remind you again that Chris Todd, on the 3rd of December, after the gag order had been put in place a day before, went on Court TV and said this.
Chris, let me start with you. This crime scene. You've seen pictures. Describe what you've seen. Take us there. Take me, everyone watching tonight, to that scene, and describe for us what is where and the significance of these locations.
I just got the crime scene photos. I just received these within probably 48 hours. So it's all brand new. I'm still processing what to make of it. It's a little sad, and it's going to be emotional for the families, for the public to see these. And I am going to bring them forward. And I guess we may not show them today, and that's okay. But these are the articles of clothing that were found in the creek.
When you talk about articles of clothing, does this suggest that there may have been some sort of sexual aspect to what happened to these young girls, based upon the clothing that you saw in these photos?
I can comment a lot more even about the actual murders themselves. We can wait for that if you'd like, through the Leo whistleblowers that we have. I do know a lot about the murders themselves.
Let it fly. Okay. Let it fly, sure. Chris.
So,
let it fly.
But from the clothes, yes, it indicates. Okay. Yes, there was a sexual assault for both victims. And there's some creepy posing and staging that occurred. But just to answer the first question is yes, the clothes in the photos, there's 3 of them. I have 3 photos. And these clothes do indicate that they prove that one of the girls was nude for sure at that moment. And I do believe through the investigation that both girls were nude at one time.
So, in my opinion, very evident that he'd seen crime scene photos. Barbara McDonald had the Purdue report on the 19th of September, even before the defence had seen that full report. Because the defence had been told that the Purdue report was lost. Well, Barbara McDonald had it! Barbara McDonald had it all the time! The Purdue report had been lost, and they couldn't remember who the Purdue professor was. And then magically they remembered. Okay. Baldwin emailed confidential work product. Yeah, Brandon Woodhouse. All right. We'll hold our hands up to that one. Baldwin and Rosie made extrajudicial statements and had a substantial likelihood of materially prejudicing the case. So they issued a press release on November 29th. This apparently contravenes Professional Conduct Rule 3.6. All right. Okay. Included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed Allen's innocence. So this is the press release. Here it is. Okay. And isn't it perfectly normal for defence teams to say that their client is innocent? I don't think that's any surprise that a defence team is going to say, my client's innocent. So, as Rick's attorneys, we have received multiple requests from local and national media for interviews and comments since the unsealing of the probable cause affidavit. It would be virtually impossible to comply with these requests and continue to focus on the merits of Rick defence. Therefore, we offer up these thoughts. We do not want to try this case in the media, and we intend to adhere to the Indiana Rules of Professional Conduct that provides guidance on pre-trial publicity. So well aware of these rules that she believes they've broken. However, the police and prosecutor's office have conducted many press conferences over the 5 years plus of this investigation and following our client's arrest. Absolutely. Indeed. The good people of Reddit were on this. All right. So not much gets past Helix Harbinger. Please enjoy the extrajudicial public statement released on November 23rd, the day after the hearing on November 22nd, where he moved for a gag order, and the gag order was then implemented on the 2nd of December. The Carroll County Prosecutor's Office appreciates the judge hearing our arguments yesterday morning and looks forward to hearing her ruling. Well, probably already knew what that was going to be because they have these little secret powwows, don't they? In my opinion. As I stated in court yesterday, we strongly believe the evidence shows Richard Allen was involved in the murder. So they're professing his guilt, but it's wrong for the defence team to profess his innocence. All right. Okay, so Richard Allen is involved in the murder of Libby and Abby Because the investigation is ongoing and given the intense public interest in this case, we feel it would be best if the documents remain sealed. Better for them. Regardless of the ruling, we believe we have a very solid case against Mr. Allen and look forward to making our arguments in trial. So they believe they've got a solid case. Okay. That's why he was so quick to side with Gull, DQing his opposition. And in fact, it's worse than that. It was his idea. It's his idea. Not because they were running circles around him and there's no way he was going to be ready for a trial in January. That's what this comes down to. So this is the actual press release here from 16 News. All right, so it's right there. It's right there. That's the press statement. But has the prosecutor been disciplined? Has the prosecutor broke any rules? No, because it's one rule for him and one rule for them. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference, which I've played in previous videos. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct to make a few comments regarding the probable cause affidavit and Rick's innocence. So, no gag order at this point. Rick is a 50-year-old man who has never been arrested or accused of any crime in his entire life. He's innocent and completely confused as to why he has been charged. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help in any way he could. Contacted the police to let them know he had walked on the trail, as he often did. Without Rick coming forward, the police probably would not have had any way to know he was even on the trail that day. So the moral of this story maybe is if you're living in a corrupt county, wherever you are in the world, don't come forward and say what you saw. Don't try to help them in any way, because it might come back to bite you in the ass at some point in the future, because there's no way that he could be identified as Bridge Guy, because doesn't really look like the sketches, does he? Rick volunteered to meet with the conservation officer outside the local grocery store to offer up details of his trip to the trail. Rick tried to assist with the investigation, told police he did recall seeing 3 younger girls on the trail. His contact with the girls was brief and little significance. Rick does not recall this interaction with the conservation officer. That's Dan Dullin, or Dan Dullard, as we might refer to him as in future, because didn't bother recording this interaction, so no one can prove what was actually said. Now, they didn't record it, or he's lost it. He'll keep looking, though. Doesn't know if it was tape recorded, but believe he scribbled notes. He did scribble notes, yeah. After Rick shared his information, he went back to his job at the local CVS and didn't hear from the police for more than 5 years. The next time Rick heard from the police was in October 2022. This was approximately 2 weeks before the contested sheriff's election, within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. So that's just a statement of fact. That's just when the arrest took place, just a statement of fact. Okay. So in the lawsuit, Thomas claimed that he, Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicised as a result of the political campaign for sheriff. Again, statement of fact. Thomas claimed in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year, so the 8th of November, won the election. Right. Okay. Rick was arrested on or about October 28th. In the 5+ years since Rick volunteered to provide information to the police, Rick did not get rid of his vehicle or his guns, did not throw out his clothing, did not alter his appearance, put on a bit of weight, but did not alter his appearance, did not relocate himself to another community, did what any innocent man would do, and continued with his normal routine. And you've got to say that he either had to be a really cocky criminal, really stupid, or he was innocent. Take your pick at this point. The probable cause affidavit seemed to suggest that a single magic bullet is proof of Rick's guilt. It's a bit premature to engage in any detailed discussions regarding the veracity of this evidence until more discovery is received, but it's safe to say that the discipline of tool mark identification is anything but a science. Well, it's contested science. The entire discipline has been under attack in courtrooms across this country, has been unreliable and lacking any scientific validity. I think it does have some scientific validity, but I think there's more confidence in it when that bullet has been fired rather than ejected without being fired. But as there's no apparent chain of custody for this unspent round, is it really admissible in court? Or if it is, what's the jury to think? Because as far as any jury might tell, that could have just been planted at the scene. When was it found? Who was it found by? All of these questions. We anticipate a rigorous legal and factual challenge. Okay, that's what they're scared of, isn't it? On Rick's behalf, we argue to have the PCA unsealed. Rick has nothing to hide. Importantly, we're hoping that we would receive tips that would assist us in proving his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted. Although it's the burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defence team look forward to conducting its own investigation concerning Rick's innocence. We appreciate those that have reached out in support. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet no mention in the PCA about a second suspect. The defence is confused by such discrepancies in the investigation. Aren't we all? Aren't we all? And we'll be in a better position to respond as more discovery is received. Rick Allen owns a Ford Focus as of February 2017. His Ford Focus is not in any way similar to the distinctive look of a PT Cruiser or smart car that was described by the witnesses. It seems that the Carroll County Sheriff's Department is trying to bend fact to fit the narrative. Well, yeah. All right. At this point in time, we've received very limited information about the case and look forward to having something more to view which is offered up in the sparse PCA. Moving forward, it's our intent to scrutinise the discovery as it's received and give the necessary attention to the volume of tips that we're receiving. To the extent we continue to discover information that points Rick's innocence, we will offer up this information to the public, so long that we are not prohibited in doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. All right, so bear in mind that came out December 1st. So before the gag order, and the very day later, she jumped to follow Nick's wishes. All right, so that's what she did. Baldwin and Rosie provided false information to the trial court. Again, weren't offered any opportunity to go and measure Rick's cell to firm up what they were saying, and it has since been vindicated by what they said about the guards, by the guards themselves, saying that Rick had been tased, that they were wearing holding patches. The wardens confirmed it. And then, of course, you want to believe the letter by Robert Baston, the inmate. Want to believe him? I don't know, it's up to you. It seems that Gull's only got 4 points now. So she seems to have dropped the tort thing. So is that not important to her anymore? Or did she just forget during her period of illness, you know, mopping her fevered brow and all that? She just forgot. Just forgot that one. What I also love about this is this statement here. So Alan's assertion that Gull must be disqualified because she removed his former attorneys is flawed. Alan does not assert that her has any personal bias or prejudice towards himself or his current counsel. Of course, she doesn't have bias towards the current counsel because she appointed them. They're her friends. So she's admitting by admission that she was biased towards Baldwin and Rosie, which is where all this issue came from. This issue is about Baldwin and Rosie, but it just shows what a crooked demon she is. Yeah, not biased towards the current counsel because they're her friends. Man alive. And then she goes on, even if Baldwin and Rosie still represented Alan, Gull has exhibited no actual bias or prejudice against them. Really? Okay, in what world? She's living in a different universe to me. And then she has the gall to say this, that she offered Richard Allen notice that his attorneys were going to be disqualified, an opportunity to be heard through written submission, as well as argument in chambers and on the record in open court. Richard Allen was denied that. So how much notice is a minute, an hour? How much notice? Richard Allen was denied access to chambers. She didn't want him there. He was denied access to open court because she sent him back to prison. And if she's saying that that's adequate notice, or he had a right to respond through his attorneys, I'm sorry, that doesn't wash with me. There's a lot more in these documents that I'm going to leave for today. Let me know what you think. I'll see you in the next video. Bye, guys.